righty, let's go on the record on cause number DC 2014959. Council, make your appearances.
Houston Smith for the plaintiff.
Michael Heibel on behalf of the defendants.
Nick Kennedy here for plaintiffs.
Say that again because you guys spoke over each other.
Mick Kennedy for the plaintiff.
Mark Seamer for pilot.
Sadie Horner for defendants PPS and Mark Carter.
Is that everyone?
I believe
All
so.
right, we're hearing a motion for leave. You may proceed.
May it please the court, Your Honor, this is a relatively simple matter. The plaintiffs timely served billing affidavits and timely filed notice of service under 1801. Defendants thereafter timely served controverting billing affidavits. By mistake, the defendants forgot to file notice of service of the controverted affidavits with the clerk of court. 1801 allows the deadlines to be modified by agreement of counsel or by leave. When this mistake was discovered, the defendants sought the agreement of counsel and agreement could not be reached. The defendants are now asking for leave for this court to modify this deadline so we can comply and file notice of the controverting affidavit. We believe that leave is appropriate because this was a procedural mistake, that there is no undue prejudice or surprise. Controverting affidavits were not buried in the supplemental responses, but were the only attachments included. The plaintiff's attorney knew we had served these controverting affidavits, and we were asking the court to modify the deadline so we can file the notice with the clerk of court. That is all I have, Your Honor.
Response?
Judge, our position is 18.001 provides a procedure for the litigants. And just as the plaintiffs have to comply with the timeliness of the filing and the notification, so do the individuals or the parties presenting counter affidavits. We believe what's the importance of having a rule if there's not compliance? In this particular instance, the defendants did not comply with the specific procedural guidelines set out by 18.001. And as a result, we must oppose it. All of the representations that have been made by Mr. Heibel is that he is correct, but there is an important aspect of notice. Notice must be filed with the district clerk. That was not done. As a result, the counter affidavits are not valid. So it's our position, since the counter affidavits essentially just gut the affidavits concerning cost and necessity of services that have been filed by the plaintiff, we have no choice but to oppose those, and that's our position. We oppose the fact that they have lost that opportunity to file those counter affidavits, or at least present them at this particular juncture. And our position is we oppose it.
So let's kind of get practical here. So we all know about the new In re Allstate case that kind of changes the game. Unfortunately, it came at a perfect time since we're incredibly backlogged, and now it's going to increase the length of a lot of our personal injury cases. But you know, we have to follow the law. So you know, I normally would suggest, you know, go ahead and give them an opportunity, and then I would make a determination. But now it's almost impossible to strike these counter affidavits. What if we did, you know, the old school dueling affidavits and let both sides, let them present their counter affidavits, let you present your affidavits, and kind of, you know, I don't want to be too difficult, but I also don't want to have this trial be increased in length by a significant period of time. So Mr. Heibel, I think it's your motion. How do you feel about dueling affidavits?
Could I please confer with Ms. Horner for a moment?
It's okay. I can answer that question,
Yeah.
Heibel. I think the court certainly has discretion to make that compromise, and I don't really see a reason
I don't
to
have that.
object.
I disagree with you completely. I don't have that.
Okay.
I don't have that discretion. If you guys agree, I'll enforce it, but I can't just order you to do dueling affidavits. So I'm trying to do this is a bad situation all the way around. I understand why Mr. Smith is taking the position he is, given the NRA Allstate case. I understand the position you're taking. I'm trying to come up with a suggestion, not an order. I can't order you to do this. If you don't want to do it, then I have to make a decision between two unpalatable choices, which I don't really like either one. And so I'm trying to come up with the middle ground that maybe you guys can agree to. But if you can't agree, I'm not going to order it. I can't order you to do doing affidavits, in my opinion.
Judge, you have the wisdom of Solomon. We agree with that suggestion.
What about the rest of the parties?
Okay, so it sounds like Mr. Smith and I should confer and then get back to you with our decision if we're able to reach an agreement.
Judge, I don't need a conference. I completely agree with what you're suggesting.
Okay, I agree as well. So it sounds like we need to do a Rule 11 agreement, Mr. Smith.
I agree completely on that. I think she's right about that.
Okay.
All right, why don't you guys do a Rule 11? I think we all know what dueling affidavits is. I hope. Do any of the other, I don't know enough about the rest of the parties in this case. Have they also had filed counter affidavits, and are they going to have to agree to this? Or
Judge, they're untimely if they do.
Okay, very untimely it sounds like. All right, well, let's get a Rule 11 on this. I appreciate it, Ms. Horner and Mr. Smith, that you guys, we're in difficult times right now with the courts, with a huge backlog, and now this new NRA Allstate case. So I appreciate both sides giving a little here to try to come up with a solution that will keep this trial of a relatively short length and we give both sides an opportunity to present their evidence. So I appreciate everyone doing that. All right, anything else we need to chat about?
No, Judge.
Your Honor. Ms. Horner, thank you so much. Mr. Smith, the rest of you guys are excused. Just give me an order. Or I guess if you can do this via Rule 11. So just give me a Rule 11 and get that filed as soon as you can. Okay.
Thank you.
Thank
Yes,
you,
Judge.
Your Honor.
Thank you, guys. You guys be safe.
You too.
Okay. I think our next case is Benedetto versus Mr. Towing. Is that right?
We are here, Your Honor.
That's the defense attorney, Mr. Reynolds.
Yes,
And I'm here for the plaintiff, Judge.
Okay. We're here on a motion for continuance. So let's get started on that.
Sure. So it's my understanding that this motion is agreed to. Trial is currently set for July 19th. Discovery and dispositive motions deadline is the 16th. So this Friday, discovery hasn't been concluded. My client has not been deposed yet. The defendant was just deposed this year in April. We haven't done mediation. The case was filed in 2020 in March. The answer was filed in December 2020. So we've really only gotten started on this the last 7 months. And a part of the delay was obviously the delay in the answer and also just the significance of my client's injuries. His allegations are that a tow truck rolled off, or his car rolled off the back of a tow truck into him, wedging him against a wall and basically shattering his legs from the knee down.
Okay.
Your Honor, she's correct. This motion is unopposed. We have had issues getting the plaintiff deposed for several reasons, including still trying to get medical records. So I agree with Ms. Carell. We do not oppose the motion.
Okay, let me just look at something real quick. Were you guys set for a pretrial today, on Friday?
I do not believe so, Your Honor.
Okay, let me just look at something real quick. All right, if you want a continuance on this, unfortunately, we're going to have to set you to 2022.
That's fine with me, Judge.
Mr. Reynolds?
Oh, I'm sorry, Your Honor. Yes, that's not a problem.
How about would May 18th or 20, I'm sorry, wrong year. Let me look at the correct year. May 17th or 24th or 31st?
I would think that far out, Your Honor. We should be okay in setting, getting witnesses lined up and so forth. So I'd currently do not have a trial setting on either of those dates. I do not believe, so I would be fine with either.
The same is true for me, Judge.
So which day do you prefer?
About
I'm fine.
17th.
Yes, that's what I was gonna say too.
What'd you say?
The 17th as well.
17th, okay. Let me, and did you submit an order with your motion for continuance?
I did, but obviously it doesn't have the proposed date in there. I believe there's a little area for it to be written in.
I don't see an order with, let me see, maybe it's somewhere else. What day did you file this motion?
May 25th, 2021, Judge.
Let me go ahead and just share screen this. I'm not questioning that you did because, but there's something wrong with, okay, do you see this? There's a motion for continuance. I don't see the order here.
Okay, I can refile it right now.
Okay, just go ahead and put in the actual date and just said the hearing was heard on July 12th, and email my court coordinator as well as e-filing it.
Okay, yes, Judge.
All right, anything else, guys?
Not for me, Your Honor. Thank you.
All right, thank you. Just go ahead and get that in as soon as you can, okay?
Thank you.
Thank you.
Have a good day.
You too. Anyone here on B12 Consulting versus, well, let me just look who's, all right, Mr. Charlie Ginn, what are you here for, sir?
Hello, Judge. We had a scheduling conference for Heather Booker's case.
Okay.
We've got an agreed scheduling order. I think it was just filed late last week. I think we've emailed that to Ms. Pinson, but I just wanted to make sure we weren't going to get DWAP'd with it.
Okay.
So,
all right. That's a good idea. Let me just take a look.
and I was just looking at the docket. I don't see that it's been uploaded yet, Judge, but I can represent to you that we have a scheduling order and that we'll get everything worked out like always.
You said you emailed her, or?
My assistant, my paralegal emailed her on Friday. I can find out exactly when if you need.
Okay. All right.
And let me just verify one thing then. So I don't want to misspeak. Yes, sir. I mean, we have the agreement. I can email it again this morning, Your Honor.
Yeah, it might be easier. Just go ahead and email Rhonda and make sure that we make sure we have it.
You bet. Is there anything else you need from me other than that?
No, that's it. You be safe, okay?
Thank you, Judge. Good to see you.
All right. You